Chris Bebel here. I'm a former federal prosecutor focusing on securities fraud cases, and I'm a former SEC attorney. Let's quickly walk through a brief, crisp presentation dealing with securities fraud and investment fraud. Suppose that you are an investor and you are enticed by a stockbroker to purchase stock in a company that supposedly has a bright, promising future. The broker induces you to buy stock in this private offering, or maybe it's a public offering. But in any event, let's suppose that this broker confers tremendous accolades on this company, creates a very bright, promising presentation. And then a couple years later, the company that appeared to have so much promise goes bankrupt. And it becomes clear that this company was a total and complete sham. Well, what do? In that type of scenario, in all likelihood, you'll just get a couple pennies on the dollar in connection with the bankruptcy proceeding. But don't give up. Don't become passive and stand idle. Assert your rights, because there's a good chance that that broker and the brokerage firm that employs him or her has liability. They have liability in many circumstances for making deceptive, misleading presentations regarding the stock, for failing to properly apprise you of the underlying risks. Why is that? That's because the broker and the brokerage firm had a due diligence obligation. They were required to roll up their sleeves and vigorously examine the nuances and the details of that company that they touted. And if they failed to do so, then it's clear they were making representations that were devoid of a basis. They had no basis for conferring such tremendous accolades on the company. And if that took place, they have liability. Now, I'm speaking in general principles. A specific legal analysis must be tailored to the precise facts and circumstances of your case. If you want to discuss your case, give me a call, 903-843-5678, or just go to my website, chrisbebel.com.